So I think when parties enter into new agreements, obviously at the start they are focusing on the positives, they're excited about the new opportunities to work together, and they often don't actually like to address what happens when things go wrong. However, inevitably things do go wrong, and I think it's always key right at the outset to consider what contractual provisions can be put in place to deal with those scenarios. It's especially a case where there may be a supply chain and risk can be passed up and down the supply chain. Really working out there, where's liability going to lie? Where is the risk going to be? So it's things about thinking right at the outset, are you going to have limitations of liability? Are you going to put in place things such as warranties and indemnities? So again, where there's a supply chain, parties often will agree indemnities, but it's worth remembering an indemnity won't stop you being pursued. It just means that you can pursue someone else as well for that loss. And also, if you're dealing with companies that may be based in different countries, then it's worth considering, well, how would you enforce any warranties or indemnities? So if there's issues about enforcement, it may be that, again, you've got to look at the contract and think, well, how can we minimize that risk? How can we minimize that exposure? And again, it's thinking about what contractual mechanisms can be put in place, or is there various types of security that can be put in place? So it may be that you agree things such as a performance bond, or you try and get some form of insurance.
And I think, again, on indemnities, it's worth remembering as well that an indemnity is only as valuable as the money that's there to pay it out.
Exactly.
Which, again, as you say, particularly if you're dealing with a business overseas that you don't know so well, you can't perhaps do quite so much diligence on it. And a performance bond might be one thing to think of.
Yes, I mean, there's various different types of bonds, and obviously you have to assess all the individual circumstances. It's effectively a guarantee that comes into play in case there is non-performance. So they're often a bank guarantee or some financial institution guarantee where the bank is based in the recipient's home country. So if it does need to be enforced against, you can have on-demand performance bonds, which could just be called against in certain conditions, or it could be that even if there's a formal dispute and when it comes to enforcement, that you can enforce against the bond rather than going to the company's local country and having to deal with the local enforcement. It's very important. So again, right at the outset of a contract and entering into a new agreement, you need to consider which law is going to govern the contract. But as you say, also, what jurisdiction, if a dispute does arise, will that be resolved in? So I think, obviously, English law is fairly popular. It's a fairly safe choice. Again, the English courts are often a popular choice in international supply contracts, as is arbitration. And with a London seat, they're very popular. And the London Court of International Arbitration, they have their own rules, obviously, as well, which are a popular choice. We'll often act for clients where there's actually no link to England whatsoever, either party or in the contract. So recently I've just been advising some companies based in Eastern Africa who have been supplying goods to Switzerland, where the counterparty is based in Switzerland. The goods never come anywhere near England. The parties haven't got any base in England. And again, they've chosen English law in that circumstance. Where the dispute should be resolved as well, and the jurisdiction, again, it's key to really agree that so you don't have satellite litigation and issues where you are then challenging jurisdiction. Again, recently we were acting where there was a distribution agreement where it was between England and Northern Ireland, which are different jurisdictions. And proceedings where one party issued proceedings in England, one party issued proceedings in Northern Ireland, and then there's a jurisdiction challenge. There's then a big fight over which court should actually proceed. So that actually is several months then, and it's quite costly as well, just resolving which court should actually handle a dispute. It's not even addressing, it's not time and money well spent on the underlying dispute.